So it said today's webinar is going to be understanding your due process rights during an agency investigation and what actions potentially could you could take or the agency could take during this time. Um, my name is Ryan Nerney, and I am the managing partner of the California office of Tully Rinckey. My primary practice areas are federal labor and employment and security clearance, and I deal with various different employment actions, including internal investigations, external investigations via EEOC, things like that. Now, as a disclaimer, the views expressed in this publication today are the authors and do not imply any endorsement by any U.S. government agency. This webinar is for information purposes only and should not be construed as providing any type of legal advice. I anticipate today's webinar is going to be maybe a little bit shorter than others. What you'll learn today in the webinar, what we hope you'll learn today in the webinar is what are the most common types of agency investigations? What are your due process rights in relation to each agency investigation? What are the implications in the event that due process rights are violated? What, if any, type of representation you can have during these various different agency investigations? What can or does occur at the conclusion of an agency investigation? And if there are any adverse actions taken as a result of the investigation, what your appeal options would be for situation. So first, starting with what an agency investigation is. An agency investigation is typically, there's some sort of misconduct or some sort of, concern that needs to be reviewed or investigated, if you will, to determine what the facts of the various different allegations are, and if those allegations are substantiated or not. There's different types of investigations. These can vary from agency to agency. Sometimes the names are different depending on what agency you work for. But typically we have like internal harassment investigations that could be both sexual or non-sexual, for sexual harassment or non-sexual harassment, command-directed investigation, CDIs, a management inquiry, very similar to a command-directed investigation, a 15-6 investigation, typically with the Department of Defense or the Department of Defense sub-agencies like Department of Army, Department of Navy, things like that. An Office of Professional Responsibility, so an OPR investigation. That's typically for the intelligence agencies, the law enforcement agencies, things like that. But, various different agencies have other names for them. And then other general investigations. Now, these are agency investigations. So, sometimes individuals can misconstrue what the investigation is for. So, for instance, these are internal. They're not like an investigation for, like some sort of criminal conduct. That's not what today's webinar is about, nor is it about any type of security clearance investigations, both of which are investigations that happen for potentially for federal employees. But today we're going to focus more on the internal investigations for allegations of misconduct and things like that. What is due process? So due process is essentially safeguards that are put in place for protection of individual rights to ensure fairness and to ensure that life, liberty, and property are not adversely impacted or taken away without the proper procedures, if you will. So internal agency investigations are a little bit unique. Obviously everybody has heard of Miranda rights, which is, the right to counsel, the right to remain silent, things like that. I'll get into a little bit of those as far as how that potentially could apply in an internal agency investigation, or if it does. But first, I kind of want to go over a couple of warnings that typically are given at the outset of internal agency investigations. And just to be clear, these investigations are typically if you are the subject of the investigation, so the one where the allegations of potential misconduct are levied against you. If you are just involved in an investigation as a potential witness or, a supervisor or something like that, where the allegations aren't against you, it's a little bit of a different process. So this is particularly what your rights would be if you're the actual subject of that investigation. So first, there's something called a Garrity warning. So this Garrity warning, it's based upon a case, I believe it's a Federal Circuit case, where essentially generally informs federal employees during these internal investigations that any statements can be used against them in court. But in this case, they can refuse to answer, and any refusal to answer will not result in any adverse action. In this case, there has to be a threat of discharge necessary in order to trigger Garrity. So without which the privilege against self-incrimination control, i.e. the Fifth Amendment. But essentially, this informs federal employees that these statements can be used in court. So essentially, it's sometimes it's usually criminal investigations, but you can refuse to answer, and any refusal will not be able to be used against you for any type of adverse action. Contrary to that, you got Kalkine's warnings, which essentially informs federal employees that their statements during an investigation won't be used against them in court. So essentially, they wouldn't be able to be used for any type of criminal proceeding. But if you fail to answer the questions, it may and probably will result in a termination action. Failure to follow instructions, failure to provide answers, potentially could even lead to lack of candor allegations, things like that. So those are the two general warnings that you get. It depends on the type of investigation, what the actual subject matter is, but those are the typical or general two warnings that you should be provided in any type of internal agency investigation. With obviously some exceptions, but that's typically the case. Also, you have Weingarten rights. These are essentially a right for employee to have a union representative present during investigative interviews. This can be implemented if you reasonably believe that discipline could occur. So essentially, if you're the subject of an internal investigation, and you are a member of a union, usually supervisors aren't members of a union, and so they can't invoke these rights. But if you're a member of a union and you want union representation during any investigative interview, you can invoke this right if you believe that discipline could occur. And again, like I said, if you're the subject of some sort of internal investigation, typically, there's a reasonable belief at that point that discipline could result at the conclusion of the investigation. So those are kind of the main aspects for, what rights you have and what the agency investigators are supposed to do, i.e. the warnings that I just went over, prior to engaging in any type of investigation, investigative interview. Now, a right to notice for investigations. So usually there's no right to notice at the investigative stage. And this is based upon the case of Warmer versus Hampton. It's a Fifth Circuit case from 1974, but essentially because this is an investigative stage and essentially the investigation is trying to develop the facts to determine if there actually is some sort of misconduct, there's usually no notice at the investigative stage. And when I say notice, I mean notice of what the particular concerns are, what the charges are, things like that. You can ask for the subject of the investigative interview by the investigator. They can provide that to you. It's their prerogative if they want to do that, because again, they don't really have an obligation under general circumstances to provide you the subject. With that being said, you can usually gather what the potential concerns are, based upon the questions. Right to counsel. So for the investigative interviews, there's no right to legal counsel typically, unless there's some sort of aspect where criminal prosecutions can occur. So again, kind of going over all of those aspects, the Garrity warnings that I indicated before, the Kalkine's warning. But in the actual investigative interview, there's no right to legal counsel. with the exception of the Weingarten rights, like I indicated before. If you meet those eligibility requirements, you're a member of the union, believe that discipline can occur, at that point you can invoke those rights. As far as legal counsel goes, most of the time you're not able to have legal counsel actually present with you in the interview. That doesn't necessarily mean that you can't consult legal counsel prior to, as far as what to expect, how to handle certain situations, things like that. But as far as actually having an attorney present, there's no right to. You can also ask, to be perfectly frank, and sometimes they will acquiesce to having an attorney in the investigative interview with you, but most of the time they will not. And then your ability to refuse to answer questions, so i.e. Miranda rights, right to remain silent. Kind of went over that a little bit with the Garrity and Calkines. So again, if there's a Garrity warning where there's a potential criminal conduct, they give you that Garrity warning. They can use those statements against you in court. However, if you refuse to answer, they can't take any adverse action against you. And again, kind of going over the Calkines warning again, it's the complete opposite of that. They can't use those, whatever you say in those interviews, against you in court. But if you fail to answer, then they could potentially take adverse action against you. So it really kind of depends, as far as your ability to refuse to answer questions, on what type of investigation it is and what type of warning you're given at the beginning of the investigation. Violation of due process rights. So what can a typical violation of due process rights look like? So I kind of went over a little bit as far as, what your rights are, Weingarten rights, things like that. But as far as due process goes, you're kind of limited at the investigative stage. Now, obviously, you have substantial due process rights after that. But again, there's various different things that an agency can't really do during an investigation. So for instance, indefinite suspensions pending an internal investigation. Typically, agencies cannot place an employee on indefinite suspension while an investigation over general concerns about misconduct is occurring. Criminal investigations are not subject to this, and neither are security clearance investigations. So if you are being investigated for some sort of crime, or if your security clearance is under review, let's say it's been revoked or locally suspended, at that, in whatever the disqualifying or security concerns are provided to the investigative agency, your agency can place you on indefinite suspension under those circumstances. But as far as like a regular internal investigation, they're not really allowed to do that. On the other hand, administrative leave, which means that basically you're on leave until and you're getting paid during that time. Typically, an agency can place an employee on administrative leave for no more than 10 work days within a calendar year. So this is important, this is within a calendar year, not per investigation. So if there's unfortunately multiple investigations during a year, they can only have those 10 days. Which applies again to most situations where the leave is related to an internal investigation, again, for misconduct. The regulation for that is 5 USC 6329 AB. This can be extended up to 90 days depending on the situation, and it could also be transitioned to investigative leave. So investigative leave is very similar, but essentially there's really no time frame for that. Now, obviously, if it gets to be, quite a long time, then you can raise some concerns. But if you're transitioned to investigative leave, there's no like deadline for 10 working days or something like that. Also, if you're a member of a union and you have a CBA, collective bargaining agreement, that also sometimes lays out what your rights would be for any type of internal investigation. This is an agreement between the union and the agency as far as what these union representatives' rights are. They cover a whole bunch of a plethora of things, but specifically talking about what rights you have for an investigation. A lot of times they reiterate and memorialize the Weingarten rights, like I went over before. But that's generally also something that can be referenced. So it is kind of a case-by-case basis as well, depending on not only what your position is, but also what what your CBA says, and what agency you actually work for. Another thing that I indicated previously, I went over the Garrity and Kalkine's warnings. So if there's a failure to provide these warnings in these particular things, or these particular situations, then that could be considered a violation of due process. There's been various different court cases, all the way up to the Fed Circuit and Supreme Court that have indicated that these rights are, or these warnings are things that, again, depending on the investigation, must be explained and indicated to you prior to commencing questioning. So if there's a failure to, and I say properly provide because sometimes they do it, but they do it incorrectly. But if there's a failure to properly provide these warnings to you, then at that point, that potentially could be a due process violation. Also, a failure to provide union representation. So again, if you invoke your Weingarten rights, again, where it's applicable, simple interviews as part of like another investigation may not be subject to Weingarten rights. Again, unless you have that reasonable belief that you could be subject to discipline as well. And what I mean by that is if you're not the subject of a investigation, if you are just providing witness testimony, unless you have a belief that you could also be implicated in some sort of misconduct, you may not be eligible for the Weingarten rights. However, if you do believe that, then you are. And if they fail to provide you your union representation when you invoke it, that could also be a due process violation as well. So what to do in the event that your due process rights are violated, or if you believe they have been violated. Generally speaking, you want to make sure you document and keep a record. If you're represented by a union and you're covered by a CBA, you want to review what that CBA says and also contact your union to see what your potential rights are. Same thing, you can contact an attorney as well and see what your rights would be, whether it's something, if, let's say on the back end, if this investigation yields some sort of adverse action, if you weren't provided your proper due process rights at that point, that could be means to overturn or, something else, reduce the penalty, something along those lines. So it's very important not only to make sure you're documenting and keeping a record, but to contact a representative, whether it's a union representative or an attorney, to determine what your next steps would be, especially if the agency decides to take some sort of adverse action against you at the conclusion of the investigation. I touched on this a little bit, but going to the next slide, representation during internal investigations. So are you allowed to have representation? Depends on the circumstances. I kind of went over that a little bit, but realistically, the majority of the time you cannot have legal representation, which means an attorney. But in various circumstances, you can have a union representative. Again, if you're covered by the CBA, you have a reasonable belief that there are, there's going to be some sort of discipline that results at the conclusion of the investigation. And at that point, you're entitled to have a union representative during the investigation. However, an attorney, different story. Usually you're not able to do that. Same thing with an other representative if they're not, a union rep and they're not, an attorney. If it's just, let's say you want to have, I don't know, a friend on, or another colleague to ensure that there, is no fishy things going on with the agency. They're not required to allow that. So that's kind of who can represent you. I kind of went over this again a little bit, but, again, if you're covered by the Weingarten rights, you want to make sure that you invoke that in the event that, you feel like there could be some sort of discipline that occurs at the end. The case that I referenced was Warmer. Again, no right to legal counsel unless you're subject to criminal prosecution. So that's an important aspect. So a lot of times agencies try to combine investigations. Sometimes they combine it, indicate that it's an internal investigation, but there's some sort of criminal aspect to it. If you work even for one of the investigative or law enforcement agencies, that could even be more of an issue as well. So that's when you really want to make sure that you not only have, your general Miranda rights if it is some sort of criminal investigation, but you also have the Garrity and Kalkine's warnings if they're necessary. And then again, if there is some sort of, criminal aspect to this, then you want to make sure that you are able to invoke your right to legal counsel, again, if there's, a criminal aspect. Now, I mentioned before, now, obviously, an attorney most likely is not able, for any administrative investigation, they're not able to appear with you in the actual investigation, but there's nothing stopping you, excuse me, from consulting prior to that investigation. So if you have any questions or concerns, want to go over what to potentially expect during these types of investigations, it's typically perfectly acceptable to consult an attorney prior to that. Potentially can happen at the conclusion of these internal agency investigations. So typically, and again, it depends on what type of investigation it is. Sometimes agencies do informal investigations, which they probably shouldn't, but sometimes they do. Most of the time, for whether it's a 15-6, whether it's an internal harassment, whether it's a Office of Professional Responsibility, something like that. In those situations, there typically is a report of investigation or a memorandum for the record, some sort of document, indicating, what they were investigating, what, they did as far as the investigation, meaning who they, interviewed, if they looked at any type of evidence, whatever, and then ultimately what the outcome was, right? So if there's these allegations that were levied against an individual, it's assigned to an investigator, that investigator typically goes through each one of the allegations and determines if they were substantiated or not substantiated based upon their investigation. Depending on the circumstances, let's say it's like an OIG investigation, Office of Inspector General, sometimes they make recommendations as far as what the potential result could be, or what, if there should be any discipline issued, any things like that. So again, at the conclusion, there's various different things that could happen, various different types of, adverse actions. Typically, if there is some sort of substantiated allegation or claim, then at that point, there could be anything from suspension to removal. You could receive warnings, whether it's written, verbal. You could do written counselings, written reprimands. I have here unofficial counseling. Unofficial counseling is essentially just, it's not documented. It's just maybe your supervisor comes and talks to you and say, hey, let's not do that again, something like that. Or essentially nothing could happen. Obviously, if there is an investigation that you're the subject of, you want number 5 to happen, which is nothing, which means that, there isn't anything that was substantiated at that point. But in those circumstances, if there are some sort of adverse actions that are taken against you, depending on what those adverse actions are, you do have some rights, to kind of go through there. As far as obtaining a copy of the report of investigation or the memorandum for record, you can request it. If there's no discipline issued, or even if it's kind of like minor discipline, some circumstances where they don't have to provide that to you. If there's a situation where they're trying to propose your removal or propose to suspend you for more than 14 days or something like that, and they have to issue you some sort of proposal, at that point, you would be able to request the documents relied upon in order to issue that adverse action, which should include any type of report of investigation or memorandum for the record or whatever was actually provided or found, I should say, at the conclusion of the investigation. So there are some things that could potentially happen if the allegations are substantiated, if there are, going to the next slide, if there are some adverse actions that are issued to you, you usually have the ability to appeal such an action. So if you without getting into the intricacies of, if you're an employee or not an employee, things like that. Typically, if you're an employee, which is if you've been employed for at least a year and are not on probation, you're typically considered an employee, although everybody has a little bit different situation, so you want to check on that first. But if you meet the definition of employee, then typically you have appeal rights for any type of adverse action. So a lot of times you're issued a proposal for any type of adverse action. If it's a suspension for 14 days or less, then you are entitled to advance written notice stating the specific reasons for the proposed action, a reasonable time to answer orally in writing, to furnish affidavits, other evidence that you think would mitigate the situation of the claims. You have the right at that point to be represented by an attorney or other representative, and then the written decision at that point should provide specific reasons for the decision at the earliest practical date. There's really no guideline to that. It's essentially when they get around to it. But so that's if there's a suspension for 14 days or less. There's very limited MSPB rights, Merit System Protection Board rights for suspension for 14 days or less. But those are generally what your due process rights are for an adverse action that happens. Sometimes if you are a part of a collective bargaining agreement, you could also grieve that, but you have to be aware of selecting your remedy or selecting your forum. So a lot of times, with the exception of a couple agencies or situations, if you decide to grieve, you can't if you don't like whatever that decision is, you can't later come back and try to take something to MSPB or EEOC or something like that. So just be kind of aware of that and what your options are. There's also due process rights. If the suspension's for more than 14 days, you get a reduction in your grade, you're removed, anything along those lines, reduction in pay, anything like that. You're usually allowed to have your 30 days advance written notice, I guess, unless there's some sort of reasonable cause to believe that there's a crime that has been committed, and then imprisonment can be imposed. But there has to be that proposed action that states the specific reasons for the proposed action, a reasonable time, but not less than 7 days to answer. Typically, agencies give you anywhere from like 7 to 14 days. Sometimes you can request extensions, but they're only really required to give you minimum 7 days, and then give you the opportunity to answer orally and in writing, and then furnish any evidence that you have to support your answer and try to mitigate whatever penalty is trying to be imposed on you. And then also be represented by an attorney. And then again, similar is you have a written decision with the specific reasons. And in this case, if the adverse action is upheld after the proposal, you do have the ability to go to MSPB in most cases. But typically the way they kind of determine what the adverse action is many agencies have what they call a table of penalties and offenses, where they kind of are giving guidance as far as what the actual adverse action is and what a typical penalty range would be. It kind of gives them guidance as far as what they feel would be reasonable. So that's kind of where agencies typically get, what type of penalty to impose. You also typically have the ability to go to the EEOC, the Equal Employment Opportunity Commission, if you feel that this action is that's taken against you is based upon any type of discrimination, reprisal, harassment, hostile work environment, anything like that. And then you could also go to the Office of Special Counsel, if you believe, or you blew the whistle as far as fraud, waste, and abuse, disclose those things, and you feel that after your disclosure that these are when the investigation started and the adverse actions occurred, and you feel that that is reprisal for your disclosures, you can also take some action with the Office of Special Counsel as well. So there are some options to happen. There are some options to happen in the event that an adverse action is issued, and that's typically where the majority of your due process rights are implemented. So that's kind of the general gist of the internal investigations. Obviously, as I mentioned at the outset, there's other types of investigations that aren't necessarily subject to kind of what I went over. Like I said, criminal investigations, situations like that, or security clearance investigations. Those are kind of outside the realm of these internal investigations. And there's other rights associated with those. And other situations that are associated with those types of investigations. So I know that there's been a few questions that have been trickling in on here. A couple were sent previous to the webinar, so I'm going to go over just a couple of those. Some of them I already addressed, but others, I'll try to get to. One of the questions was, can you leave a federal job during an investigation? If it's an internal investigation, yes. There's nothing really stopping you from doing that, because if the internal investigation results in some type of adverse action, then at that point, I mean, it could potentially lead to removal anyways. Typically, if you leave during an investigation before there's any type of outcome, if you will, you usually can. With that being said, there could be some potential implications as far as like security clearances go, in the event that you're told that this could possibly lead to your termination, or you're provided information that this is misconduct and they're going to investigate it or whatever. Those are things that typically have to be disclosed on any type of standard Form 86, at which point you would have to disclose that, and that could lead to some potential issues for security clearances down the line. But if that's not a concern, then I mean, there's really nothing stopping you from leaving during the investigation. Another question is, what results from an investigation, or what results from an investigation would be reflected in FOIA? FOIA is subject to the Privacy Act, and if you request information based upon yourself, a lot of times you can get that information that's unredacted. But most of the time, if it's an internal investigation, or even if it's like a security clearance investigation or something like that, a lot of times, and again, it depends on the agency, but a lot of times that information is redacted. There's various different clauses and laws within the Privacy Act, or sections within the Privacy Act that allow agencies to kind of redact that information. So, and sometimes they hide behind the Privacy Act to prevent you from getting that information altogether. There's various different aspects to that on what they can cite, but sometimes they do that. So my answer to that question is potentially. It just kind of depends on the situation. But the best thing to do if you're curious and there was an investigation and you want to find out, best thing to do is submit the FOIA request and find out if you can actually get that information. Another question kind of along the same lines, are there any tips on obtaining a copy on the result of the investigation if we need to submit a FOIA request? A lot of times you can simply request, if you're still an employee, you can request a copy of the any type of report of investigation. Sometimes they'll give it to you, sometimes they won't. Sometimes they'll just refer you to FOIA, and then at that point you can request the information through FOIA. So, if that's the case, that is, something that you could do and look into. Each agency has various different locations and processes for submitting and processing FOIA requests, and the amount of time can vary depending on the agency as far as obtaining the actual response to that. And when I say response, I mean the documents that you requested, or the response saying they can't give you those documents, not necessarily just like the acknowledgement. Some agencies take a year or more to get that information to you. So just be aware of kind of that time frame. How does somebody know if you still have a job once your case has been concluded? Well, if you're an employee, like I said, if you're an employee and the agency is going to remove you, You do have due process rights at that point. Like I said, they have to provide you written notice 30 days before any type of adverse action. If it is a removal, with the specifics as far as the allegations on why they're removing you, give you an opportunity to respond with representation, and then ultimately they'll issue a decision. So if they are going to remove you and you meet the definition of an employee, then at that point they do have to follow a procedure, a process in order to remove you. If it's based upon the outcome of that investigation and any type of misconduct. Is there a time frame for an agency to close the investigation and give a final decision? Not really, because internal investigations, the investigators and the agencies want to ensure that they are getting all of the information they need. So investigations are typically fact-finding, right? So they're trying to go through, interview witnesses, obtain evidence, things like that, to essentially determine if the allegations that were levied against you were substantiated or not. So, depending on the severity of the allegations, the complexity of the allegations, the time frame for investigations can vary widely depending on those things. So, there's really no set time frame. Now, they should try to conclude it as quickly as reasonably able, but realistically, it really kind of depends on the circumstances. Can they record an investigative interview? Depends on the situation. It depends on what type of interview it is. Typically, agencies have regulations in place. They would have to notify you of that. They would have to, in some instances, you would have to agree to it. Kind of goes the same way as well, the opposite way. In circumstances like, let's say, like a security clearance investigation, or if it's something where, there are criminal implications, they could admonish you as well, and basically put you under oath. So everything you tell, you could be subject to, the penalty of perjury, things like that as well. So, that could happen potentially. It just kind of depends on what type of investigation it could be. Can a witness to an investigation become a subject of investigation? It wouldn't necessarily be the subject of that investigation. Usually, if that would happen, then that would be a situation where they would open up a new investigation based upon any, misconduct or issues that they find. So potentially, yes. And that's kind of where I was discussing, if you're a union member and you have Weingarten rights and you do have a reasonable belief that discipline could be levied against you, even if you're a witness in an investigation and not the subject of one, you can potentially have your Weingarten rights invoked at that point as well. But to answer that question, yes, I mean, you can, if there's information that comes out during, witness testimony, during an investigation for somebody else, that could potentially lead to, an investigation of you if there is any type of misconduct or something like that. I hope everybody enjoyed the webinar and was informed as far as the circumstances, situations that can happen during internal investigations and what potential rights you have during those investigations. So thank you, everybody, for joining, and everybody have a great day.